The hearing will come to order, and we have some conflicts. We are trying to crowd a lot into a few weeks, so I'm going to call on the ranking member to give his opening statement, and then the gentleman from Texas, I believe, also. The gentleman from Texas, Mr. Hensling, was he? All right, and then we'll if that's right, we'll then finish it because they have other business. So the gentleman from Alabama is recognized for
2.5 minutes.
2.5 minutes.
Thank you, Mr. Chairman, for holding today's hearing to examine the broad exemption from the Freedom of Information Act accorded the SEC under Section 929I of the Dodd-Frank Act. Let me also thank Chairman Schapiro for being with us today and for her willingness to work with the committee in a spirit of bipartisanship and cooperation to address the concerns that have been raised about Section 929.1 by Congressman Issa and others. The Dodd-Frank Act confers significant new supervisory and investigative authorities on the SEC. Combining these powers with a provision that appears at first blush to insulate the SEC from public scrutiny has caused some alarm among members on both sides of the aisle. This hearing provides a welcome opportunity to address some of the confusion and to consider a solution that ensures proper accountability at the SEC while not undermining the agency's important ability to exercise effective supervision over thousands of firms it's responsible for overseeing in the post-Dodd-Frank world. To her credit, Chairman Schapiro has been candid with the committee and with the American people in acknowledging past failures of the SEC and protecting investors and regulating large investment banks. We can all agree that the agency that presided over the collapse of some of the largest financial institutions on Wall Street and allowed Bernie Madoff, or were apparently unable to stop Bernie Madoff from perpetrating the largest financial fraud in American history, must be more transparent, and any statutory departures from a general policy of openness must be crafted carefully. Unfortunately, Section 929I, and I think Congressman Towns and Issa agree, doesn't meet this standard for good legislative draftsmanship. And the provision's broad wording has given rise to concerns that it could be invoked to withhold information the public has a right to know, but the SEC would prefer to remain secret for fear it would be cast in an unfavorable light. At the same time, no one questions the SEC's legitimate and important need to preserve confidentiality of certain materials it collects during the examination process. In fact, some of these would be protected by contract law.
Do you gentlemen want an additional 30 seconds?
Just five additional seconds. And let me close by commending the chairman on something else. The Commission's anticipated action to prevent window dressing, the transfer of liabilities off balance to improved month-ending reports, very similar to the Repo 105 tactics at Lehman Brothers, I think is a signal of changing attitude under Chairman Shapiro's leadership, and I commend her. Yield back the balance of my time.
Thank you, gentlemen. And the gentleman from Massachusetts, Mr. Lynch, is now recognized for 2 minutes.
Thank you, Mr. Chairman. I want to thank the ranking member as well. And I'd like to welcome our witnesses today, my other chairman, Chairman Ed Towns, and also our ranking member, Darrell Issa. Thank you for your good work on this. I also want to thank Harvey Pitt, who will be testifying a little bit later on the third panel, and whose opinion I greatly respect. As many have noted, since the passage of the regulatory reform legislation this past summer, the SEC gained significant regulatory responsibilities with this new bill. I've always believed that it's important to provide regulators with the proper tools and resources, as well as a certain amount of flexibility to do their jobs and accomplish their mission. A recent example of the importance of the SEC's regulatory abilities was evidenced in the aftermath of the flash crash in May. High-frequency trading is suspected to have played a role in the crash. However, as Chairman Schapiro noted in her letter to us on July 30th, actually it was a letter to Chairman Frank, high-frequency trading firms have historically been reluctant to provide information on formulas to the SEC out of privacy concerns. Now, this obviously can hamstring the efforts of investigators to determine the cause of the crash and how to prevent another one in the future. Section 929I addresses this very issue. It allows the SEC to protect the information and records it and records it receives from regulated firms. It's also a fact that I am sensitive, however, to the criticisms of the provision, citing the need for more transparency within financial regulation, not less. I believe prudent checks and balances are necessary within our financial system, so I appreciate the opportunity to discuss the legislative proposals before us that would affect this provision. Again, my thanks to the witnesses, and I thank the chairman, and I yield back.
Gentleman from Texas, Mr. Neugebauer, for 2.5 minutes.
Yeah, thank you, Mr. Chairman. Thank you for holding this hearing. This is the first hearing, I guess, that we've had on Dodd-Frank since the law became law, and I probably won't be the last. When you have such massive legislation that creates so many new programs and authorities, the rulemaking authority, I suspect we will be looking back on many of those provisions. You know, the purpose of government should be only to make sure that there's integrity and transparency. And we put and give certain agencies the authority to do that, to ensure that there is integrity and transparency in the marketplace. And we have given the SEC a lot of authority, and I think some people think too much. One of the things that we do want to do is in their normal course of business, we want to make sure that they are able to collect the information that allows them to regulate the entities that they are supposed to oversee. But at the same token, we want them to be protective of that information when it is proprietary to those particular companies. But by the same token, too, the SEC needs to be accountable for their actions. And one of the concerns I think a lot of folks have about Provision 929I is that it might give the agency some leeway there to claim that certain information is privileged under 929I, and that that information would not be available, and that the transparency, integrity piece of government then is violated. And so I'm glad that we're having this hearing today. I think it's important that we get this right. We rushed through a lot of these provisions as this bill was being marked up, and it's important that we go back now and make sure that if in those areas where we didn't get it right, that we do get it right. We owe that to the American people. We owe it to the people that are relying on the SEC to protect their investment. And with that, Mr. Chairman, I yield back my time.
Well, I'll yield myself 3 minutes. And the gentleman's statement that we rushed through these provisions is flatly inaccurate. In fact, with regard to this particular provision, and we're here to think about changing it, narrowing it, make it more specific, it was first essentially put before us by Chris Cox in 2006. I don't think that's a big rush. Chris Cox was chairman of the SEC under President Bush, and he asked for it. In 2008, we were again asked for it when Chairman Cox was still the chairman, and this committee voted out a bill unanimously that included it. Maybe the gentleman from Texas was rushed that day when he apparently didn't object to it, but that was over 2 years ago. And it went to the floor and passed on suspension. This has been around for a while. It was then introduced again in 2009 in both bodies. It was before us when the subcommittee voted on the provisions, or the committee that Mr. Kanjorski had worked on. It was there. It was then in both bills throughout the conference period. The base text was posted on the 10th of June. So it's been out there all during the conference. Members had a chance to look at it. Yes, it's a big bill. It has a lot of separate sections. We worked on it for well over a year, and while we're now getting complaints that we rushed through it, we also had complaints we were having too many meetings and hearings. So this is a serious subject, and I think talking about it being rushed through demeans inaccurately the seriousness of what we're trying to do. What happened apparently was there was a lawsuit that had been brought looking for information, and it became clear that this provision could have interfered with that lawsuit. Now, that was not something Chris Cox could have foreseen in 2006. I don't think Chris Cox was trying to hide anything in 2006. We have Harvey Pitt's testimony here. Mr. Pitt, I don't think, was trying to hide anything. There's a serious fact here that a legitimate issue to them now appears to have other consequences. What I'm told by Chair Schapiro, and she's tried very much to beef up enforcement, is that the initiative for this came from the enforcement people who said, if we aren't able to protect some proprietary information, it will be harder for us to get it. And that's the purpose. No one, I hope, thinks we should be in any way shielding the SEC. I am convinced that it went too far. as I said, it's been something we've been talking about for 4 years. It wasn't until this lawsuit that people were able to look at the conflict. I would hope we could discuss this in a serious manner. And now the question is, there was the absolute need for unmitigated transparency with regard to the SEC. And the question is the SEC doing its job? And as the SEC has to understand, there have been too many examples of its not having done its job recently for people to rest easy on that. On the other hand, we don't want to make it harder for the enforcement people to get what they need. I don't know whether there's a way to sort that out. Senator Leahy had a bill. He tried to hotline it. It was not hotlined. Let me say, and I'm going to give myself another 30 seconds, it is clear that legislation is required, I believe. I know the chairman has done a very good job of trying to make this specific, but I think given this legislation is probably necessary, we will be looking at it. We have time to do something, and the Senate, for once, is interested in doing something. So we will be dealing with it. But let's again be clear. This was a bipartisan request that's gone through 2 administrations from 2 SECs. It was generated by the enforcement people. It's been out in public and debated in this committee, another 30 seconds I'll give myself, for several years. Once someone noted that there was a conflict between that and the lawsuit, it came to our attention. We promptly had a hearing. That is an appropriate way to go, and it is my intention to work together, I hope in a bipartisan way, with partisan cracks along the way that I suppose come to the territory, to resolve this in an appropriate manner. And the gentleman from California is recognized for 2.5 minutes.
Thank you, Mr. Chairman, and I will neither debate nor challenge your history on how we got here, but I'm one of the bipartisan bicameral bills, or a part of one of the bills that are both bipartisan bicameral dealing with this. And as the chairman suggested, we're here today because of a Fox Business Network lawsuit and information request. And an information request, my understanding is, was on Bernie Madoff and Alan Stanford and those Ponzi schemes. Now, we all understand the need with the Freedom of Information Act, to protect confidential and proprietary information of the regulated entities. But I think at least for this member, and I would presume for many of the other members who have introduced legislation, it is difficult to understand why anything involving Bernie Madoff and Alan Stanford is proprietary confidential information that needs to be protected under the Freedom of Information Act. That leaves us all to perhaps a conclusion that maybe what we're trying to do is shield, in fact, the SEC and perhaps some actions of the SEC. Now, as we look at the financial markets and the financial industry, both going in the past and going forward in the future, certainly there are regulated entities that are under both SEC scrutiny and legislative scrutiny for actions in the past, and will be for actions in the future. But the SEC should not be immune itself, the regulator should not be immune itself, not just the regulated, from the scrutiny of this legislative body as well. And it would appear that this Section 929I is, and I agree with the chairman, overly broad, and permits the SEC to shield itself from scrutiny by this legislative body, which I think is inappropriate. But I look forward to hearing both the testimony of the members at the table now, and then the chairman of the SEC later. Thank you very much. I yield back.
No further requests for time, but before me, so the gentleman from New York, Mr. Towns, is chairman of the Committee on Government Reform and Oversight, is now recognized.
Thank you very much, Chairman Frank and the ranking member, members and staff of the Committee on Financial Services for inviting me today. The landmark Dodd-Frank Wall Street Reform and Consumer Protection Act made significant improvements to the accountability and the transparency of our nation's financial system. The Act gives consumers access to more information about investments, and it reins in the abusive and excessive practices of Wall Street. Passing the Dodd-Frank Act was an important achievement, but our work in Congress did not end when the bill was passed. It is critical that we exercise vigilant oversight of implementation and that we act to close loopholes when they are identified. To that end, I applaud you, Chairman Frank, for your willingness to hold this hearing to examine a significant loophole. that I believe undermines the core purposes of the Dodd-Frank Act. Section 9291 of the Act would allow the SEC to avoid disclosing information the Commission receives during examination of companies if the information is used for surveillance, risk assessment, or other regulatory and oversight activities. This language is too broad. It allows the SEC to keep secret virtually any information it obtains under its examination authority. SEC Chairwoman Mary Schapiro has asserted that the Commission will only use Section 9291 as intended. But the SEC has already indicated its willingness to exploit this loophole. In an action the SEC brought against a broker-dealer, the Commission tried to use Section 9291 to avoid an administrative law judge's order to comply with the subpoena. That clearly goes beyond the intent of the provision and the SEC's reasons for needing the provision in the first place. Chairwoman Schapiro yesterday issued guidance that places limits on the Commission's use of Section 9291. This is a step in the right direction, and I do agree with that. But the chairperson's guidance is not sufficient because the Commission can change its interpretation at any time, and the fact that guidance is needed at all is evidence itself that the provision is too broad and subject to abuse. The SEC's rationale for Section 9291 is that the provision is necessary to ensure that the Commission can obtain sensitive information when the Commission is performing examinations. Mr. Chairman, I introduced H.R. 6086. On August the 10th, 2010, H.R. 6086 repeals the secrecy provision of Section 9291 and amends the Securities and Exchange Act to clarify that any entity the SEC regulates under the Securities Exchange Act will be considered a financial institution for the purpose of FOIA Exemption 8. My bill strikes a careful balance to address the SEC's concerns without compromising the goals of transparency and accountability that are the heart of the Dodd-Frank Act. In a letter supporting H.R. 6086, a coalition of 36 public interest organizations, including groups such as the Project on Government Oversight, the Sunlight Foundation, and OpenTheGovernment.org, wrote in support of this legislation. This bill sends a clear message that public access is vital to accountability. I am submitting a copy of that letter for the record today. The culture of accountability must start at the top. Allowing the SEC to operate in the darkness or secrecy will undermine the confidence of consumers and regulated companies. I look forward to continuing to work with you, Chairman Frank, and the committee so that we can quickly and effectively address this issue. I want to thank the members of the committee. I want to thank you, Mr. Chairman, for holding this hearing today. And I really feel that this is a start to be able to correct something that could be very detrimental as we move forward. On that note, I yield back the 3 seconds.
That committee will have 5 minutes and 3 seconds.
Thank you, Mr. Chairman, Ranking Member Nagarbar. I respect the fact that this is the committee of jurisdiction that does oversee the SEC, and that the nuances of what should or should not be made available under FOIA to a great extent falls within this committee. Chairman Towns and I are here because we represent the committee that is really about transparency. We will always be the committee that probably starts off assuming that everything should be available unless otherwise justified. Chairman Towns' bill and what one might call a companion or similar bill, 5924, which I also authored, really try to unring the bell. That's our position. Our position is you start over, you essentially undo what happened in the Dodd bill, and then you thoughtfully and carefully weigh what Chairman Cox brought, Chairman Schapiro is bringing, and don't give them what they ask for, what they want, give them what they need. The decision of what they actually need in the long run will be yours. But let's assume the following. Every bureaucrat, no matter how well intended, always wants to err on the side of caution and less. Well, the public believes that they should err on the side of more. Now, as I look down at Mike Oxley above the chairman, I remember that, in fact, Sarbanes-Oxley passed under many of your watches. I'm perhaps the only member of Congress serving on a public board both before and after that, taking a company public and watching as we went through the SEC process. The Securities Exchange Commission is not an enforcement agency first. It is not the FBI. It does not deal in vast secrets. It is, in fact, an agency that exists for no other reason primarily than to ensure transparency of the information and honesty of the information that public companies put out there in order that there may be public confidence, trust, and thus the free flow of funds to investments. The SEC exists in no small way in order to create transparency and honesty. Now, of course, they have an enforcement responsibility, and often they ask for additional information and information that should not be made public. But make no mistake, the SEC is about asking for proprietary information to be made public as a part of what they do. We all know that you can find out a great deal about a company, far more about a public company than you can a privately held company as a result of their wanting to be before us. As Congressman Campbell said, it is impossible for us to understand how criminal enterprises such as Bernie Madoff's can in fact continue to enjoy some level of protection from scrutiny by the public. So, Mr. Chairman, we are coming before you here today to a great extent not to debate whether suggestions made by Mr. Cox or now Chairwoman Schapiro are in fact appropriate. That's your decision to be made in good time. But we are asking you to consider legislation that would effectively unring the bell, allow that process to go forward without prejudice based on what was put in the bill that we believe was overly broad. I might point out to the committee, not that you wouldn't already know it, but perhaps for the public, that the SEC, prior to this 929I, only granted 13% of FOIA requests, and as far as we can tell, was only overturned when they denied once. So this is an agency that knows how to say no, has the power to say no, and says no most of the time. I think that's one of the reasons that in my letter to Chairwoman Schapiro, which I would ask unanimous consent be placed in the record,
Without objection.
we pointed out some of the details of that history. Not to say by any means that her guidelines were inappropriate and weren't a good step, but that in fact, if we unrang the bell here today, they still only would grant about 13% of FOIA. They would fully protect companies' secrets. And if they can't, I certainly want to make sure that this committee, in its due time, ensure that we do provide them the tools they need. I might note that there is a legitimate reason to say that no one should ever be able to use the Securities Exchange Commission to backdoor their way into information that would not otherwise be available through FOIA. That's a good point and a good starting point. So as we take this step forward, I would hope that the members of the committee who have the absolute jurisdiction would start over to the extent possible, give us a quick remedy from an overly broad prohibition on FOIA, and then appropriately listen to Chairman Cox and Chairman Schapiro in the future. And thank you for the extra few seconds. I yield back.
Thank you. I just, not by the question, but just again, I want to be very clear. That's why we're here, and it is because Fox filed that lawsuit, and it was in the course of that lawsuit that people discovered the problems. I just want to note, again, to repeat, in 2008, the House passed this bill, a bill including this unanimously. Some of the people who are now for repeal were co-sponsors. It was put in 2009 when the committee debated the part of the financial reform bill of which this was a part, 45 amendments were offered, and none of them affected this. That is, nobody at the time, when we had a long set of markups, thought about it. It then went to the floor of the House. It was in the House. It was also in the Senate. 241 amendments were filed to the Rules Committee. None dealt with this. And then members will remember with varying degrees of joy the conference process, during which every member of the conference offered amendments on a variety of subjects, and nobody offered an amendment on this. So this has been out in public view, and I simply say that to be clear, because the question is, well, why? How did this slip through? It didn't slip through. It was plausible language. Often you don't know something until it's time tested, and it was the lawsuit that tested this. So that's why we are here. Having been through all this, having had it laying out before all of us who were here, and everybody here, conferees here, 3 of us conferees there, 2 conferees there, it just didn't occur to anybody until it was called to our attention, and I believe the Congress is now acting appropriately. And I think what the gentleman from California suggested, we do have, let me just say, by way of procedurally, we have a short time period now, and it may even get shorter. And there are 2 possibilities. One is that we try to amend it. I think it's clear that something should be done. Either we try to amend it some ways, New York has proposed, or it's a two-step process of a repeal with a note that this should not be left undone and reapproached, and whether that would be later this year or next year, it could be done. Because again, as I said, the history of this makes it very clear. It's been totally nonpartisan, so we can work on that. Do any other members have any comments or questions for our colleagues? If not, according to the custom, we thank them, and we will be working with them. Let me note, yes, it is within our jurisdiction. One of the things I am very proud of with regard to this committee is that we have engaged in no turf battles with anybody, because I think that is Congress at its worst. When we are engaged in jurisdictional battles, we appear to the public to be just interested in sort of prestige. We had the full participation of both of these members in the conference, not restricted de facto to what we talked about, and we will be drawing on the expertise of that committee, which has jurisdiction over FOIA, as we proceed. So I thank both gentlemen.
I thank the chairman, and I'd just ask unanimous consent that our statement from, our report from May be included in the record as part of our submission.
The report on the SEC?
On the SEC, yes. It's a published report.
So why do you have to publish it again?
I would note for the record that you're right.
Thank you.
Thank you, Mr. Chairman.
We will now call the chairman, Mayor Schapiro, and I thank the gentleman. As the chairman takes her place, I would ask unanimous consent I ask unanimous consent to include in the record a statement from the Society of American Business Editors and Writers, not previously published, I would know. And I take it back, it has been previously published. We'll put it anyway, it's short. Without objection, it'll be included. And Chairman Schapiro, let me say I appreciate your coming, and I just want to say in the outset, no one, I think, does or should consider this in any way any kind of criticism or indictment. And I understand you, my own view is that you have significantly improved the enforcement mechanism. I know Mr. Kuzami couldn't be here today because of impossible conflicts, but I welcome him and what he's been doing. So I want to make very clear, and I think everybody's made this clear, we're here in a spirit of cooperation. We have a common enterprise. We have conflicting goals to some extent, which is tough enforcement, but also complete openness. And I think in good faith we will work together there. So, Chairman Schapiro, please begin. And as the chairman, and this is a complicated subject, I don't think anyone would object if we give you the flexibility to go over the 5 minutes that we give some other, from time to time. You're a one-person panel, so we can do that. Go ahead.
Thank you very much, Mr. Chairman. Chairman Frank, ranking members, Member Bacchus, and members of the committee. Thank you for the opportunity to testify today on behalf of the Securities and Exchange Commission concerning Section 929I of the Dodd-Frank Wall Street Reform and Consumer Protection Act. Section 929I was designed to improve our examinations of regulated entities by clarifying the protections afforded to regulatees that provide the Commission with sensitive and confidential materials as part of those examinations. It is a provision that we raised with Congress for several years in both a bipartisan and transparent manner. Indeed, as the Chairman has noted, 2 years ago the House of Representatives passed language that, while not identical, was substantively the same in its protection of examination documents as Section 929I. Among other things, the SEC is responsible for examining in excess of 17,000 entities that play central roles in our capital markets, including investment advisors, broker-dealers, and credit rating agencies, to name just a few. During those inspections, our examiners frequently request confidential and sensitive business records that are critical to our oversight. Yet, because of uncertainties in the law, some regulated entities have expressed concern about the Commission's ability to protect those documents from compelled disclosure to the public or to their competitors. That ambiguity has impeded our ability to obtain vital examination information on a timely basis. Section 929I was designed to eliminate this substantial and long-standing impediment and facilitate more thorough and efficient examinations. 929I was never intended to exempt the SEC from the Freedom of Information Act, nor does it. FOIA is a landmark law that guarantees citizens access to government information, provided certain exemptions do not apply. In the case of the SEC and other financial examiners, FOIA seeks to balance the public's right to information with the government's responsibility to provide effective supervision. Though FOIA, through Exemption 8, does provide important protections from disclosure for examination materials obtained from financial institutions, that term is not defined in the law. Indeed, courts have not yet addressed whether certain entities the Commission has the authority and the responsibility to examine, for example, credit rating agencies, transfer agents, and municipal advisors, are financial institutions for purposes of these FOIA protections. Additionally, existing FOIA exemptions do not apply, of course, in non-FOIA contexts. So when a private party, in litigation with another private party, subpoenas documents from the Commission, potentially about its competitors, that the Commission has received through its examination program, the Commission has had to rely on arguments of undue burden, relevance, or common law privilege to protect the information from disclosure. Section 929I appropriately provides needed protection in this non-FOIA litigation context. Rather than use the Commission to gain access to information, private litigants should have to seek documents from the registered entity, which is, after all, best positioned to articulate the sensitivity of that information. While the Commission believes 929I will improve its examination program by facilitating better and more timely access to vital information, it also shares a commitment to accountability and the transparency that is embodied by the Freedom of Information Act. The Commission recognizes that Section 929I is meant to balance the public's right to information with the benefits of a robust examination program, a balance that is recognized under FOIA as well. To ensure that these important and competing interests were appropriately balanced, including in the third-party litigation context, last month I instructed the staff to refrain from invoking 929I until the Commission issued guidance as to when and how to assert this provision. Yesterday, the Commission issued clear guidance to the staff on the appropriate use of 929I. A copy of that guidance is attached to my written testimony. With respect to FOIA requests, the staff and the Commission will continue to rely on existing FOIA exemptions and use 929I only where the information is obtained through the examination program and where the courts have not yet determined whether the examined entity is a financial institution. With regard to third-party or non-FOIA litigation, 929I will only be invoked where the information, had it been sought via FOIA, could have been protected under existing FOIA exemptions, and then only when the party cannot establish a substantial need to obtain it from the Commission. 929I will not be invoked in any matter where the SEC or the United States government is a party. Finally, you've asked that we comment on the bills introduced that would explicitly or effectively repeal 929I. I am concerned that these bills, as currently drafted, may not provide certainty to regulated entities concerning the protection of their proprietary information. In addition, none of these proposals address instances in which third parties seek to compel the Commission to produce documents in non-FOIA litigation through third-party subpoenas. I'm therefore concerned these bills would diminish the Commission's ability to obtain in a timely fashion the information needed for comprehensive examinations. In sum, 929I is important to our ability to develop a robust examination program that better protects investors. As you know, our examinations help us to identify compliance errors as well as wrongdoing. And where wrongdoing is uncovered, these examinations result in referrals to our enforcement division. A vigorous enforcement program goes hand in hand with a good examination program. Though we recognize the competing policy interests it raises, a return to the status quo ante will again limit the efficacy of our exam program. I do believe the Commission's guidance strikes an appropriate balance by addressing the primary issues that existed prior to this new law, while simultaneously protecting against its application in a broader than intended manner. Thank you very much, and of course I'm happy to answer your questions.
Thank you very much, Chairwoman, for being here today. I'll recognize myself for 5 minutes. Chairman Schapiro, the SEC has been asking for this authority for some time. In addition to some regulated entities, some regulated entities have refused to provide requested information with the SEC out of fear that the information would later be subject to a FOIA request. Can you provide specific examples of an instance where having the new confidentiality provision would have allowed the SEC to better enforce its rules and regulations against a financial institution?
Yes, I'd be happy to. We have a number of examples where we have sought information that regulatees were uncomfortable providing the Commission because they felt that if we could not protect it from public disclosure, they could suffer serious competitive harm. And that would be public disclosure either through FOIA, where Exemption 8 might not clearly cover the materials and protect them from disclosure, as well as disclosure through private litigation. That would include, for example, instances where we have sought from proprietary trading firms their algorithms for trading. Their fear was that their algorithms that they use to dictate how they conduct their trading is highly proprietary, and they would suffer a severe disadvantage if that information was disclosed. We've also had instances where a registered investment advisor that manages a very large number of very large funds refused to provide the Commission with detail about its quantitative trading strategy for fear, again, that that information could become public and others could trade against that information to the disadvantage of those large funds. We've also had instances in the context of looking at insider trading where firms have been uncomfortable turning over to us what they call their watch list. Those are the lists that are maintained by investment bankers to track companies on which they have insider information to ensure their employees are not trading on that information. And there are some examples of discomfort in that regard. And then a final category would be with respect to the provision of internal audit reports that have been done by regulatees that they have not wanted to turn over to the agency. So sometimes we can't get the information. Sometimes it takes a very long time for us to get the information ultimately from these regulatees.
Have you ever, or do you have an example of where you have, you've seen proprietary information used in a way to advantage a firm or to disadvantage a firm, that information that you had in your possession?
Congresswoman, the issue would be the firm's reluctance to give us that information in the first instance, because if it were made public, proprietary trading firms' algorithms are essentially their trade secret. It's their formula to Coca-Cola. And if that information becomes public, then others can trade to the detriment of that firm and its intellectual.
So what you're saying is you have had 100% refusal to give certain information. You have not received information that has violated confidentiality.
No, not 100% refusal, certainly. We have had instances where we have had refusals and very long and protracted negotiations to try to find a mechanism through which these entities would be comfortable giving us the information. We do, at the end of the day, have the ability to subpoena the information. But I would really prefer not to see our enforcement program, which has so much to do with respect to fraud and manipulation and violations of the federal securities laws, turned into a mechanism for suing firms just to get the production of documents that frankly should be produced to us in the course of the routine examination program.
Thank you very much, Mr. Nogabar.
Thank you, Chairman, for being here today. One of the things that, as I listen to this discussion and I listen to the testimony, one of the kind of questions that comes up, some people say the reason we're here is because of the Fox Business News lawsuit. And that was more about, what was, I think, as I understand it, their inquiry was more about what the agency's behavior was in their investigation to these two entities, and not necessarily about any top secret information that you may have requested from these entities. Yet we've had a lot of discussion here today about asking these entities for more detailed information on their trading models and stuff like that. I think two questions kind of come to my mind. Is one, these seem to be two different issues, and can you differentiate to me the difference of someone getting information on the behavior of the agency as opposed to someone who getting information on the behavior of a company that the agency is overseeing?
Congressman, I think there is a difference, and I think it's very worthwhile to explore that difference. In the Fox litigation, which I should say is before a federal judge and who will make the ultimate decision about the remaining documents to be disclosed or not, Fox sought tips and complaints and referrals that had been received by the agency with respect to Madoff. They sought 2004 and 2005 examination information, 2006 and present enforcement investigation, and information coming out of our Inspector General's investigation of how the agency handled Madoff. Tens of thousands of pages of documents have, in fact, been turned over in that litigation. I agree with you that 929I should not be about shielding the Securities and Exchange Commission from accountability for its failures or for the actions that it takes, whether or not you view them to be failures in any particular context. I would say two things about that. One is that in response to Congressman Campbell, nothing in 929I prevents Congress from getting complete access to everything. It's quite explicit in the provision. Congress has full access to the agency for purposes of oversight. But in the guidance that we've published that will bind our staff, 929I may never be invoked where the agency is a party, such as in the Fox litigation where Fox has sued the SEC, or where the United States government is a party. So I understand and appreciate very much the point that we must be accountable, not just to you all, but to the public, and that by relying only on FOIA exemptions, we think we can do a lot to ensure that there is a flow of that information about the agency to the public realm. The last point I would make is that we do have exemptions under FOIA for investigations and material to prevent the disclosure of material that would interfere with an active investigation or ongoing enforcement proceeding. In the Madoff context, there are multiple ongoing enforcement proceedings, and so that exemption, 7A from FOIA, has been invoked with respect to some of those documents.
And I guess you've heard and you've received letters from various members about the concerns about your implementation of this and the broadness of it. And you have in yourself issued guidance on the use of 929I. Is it your position that you would support legislative language that would clarify and give a more specific guidance on this, maybe even keeping with even some of your direction that you issued in your guidance?
Congressman, I very much would. I think codification of the guidance that limits the agency's discretion very dramatically, I think would be a very good step. We're very anxious to work with the committee to try to get to the right result here. We want great examinations. You want us to do great examinations. We also want to protect businesses' ability to have sensitive and confidential information in the hands of government without it necessarily being broadly exposed.
Yeah, I thank you, Mr. Chairman. You back?
The gentleman from Texas formulated an important question. That is, one option would be to statutarize the guidance, because guidance can come and go. And that, I think, is one of the things we should consider. In other words, I guess there might be some agreement conceptually, but it isn't always easy to translate the concept into reality. That is, we would all agree, and you, Chairman Schapiro, have said so, the SEC shouldn't be shielded in any way from the media, from the public, from Congress, which it wouldn't be anyway. The only question is there some concern that if there was nothing along these lines, you would encounter more resistance in trying to get proprietary information? And I guess particularly the question would be, if you got proprietary information and there wasn't anything wrong, would people have that at risk? I don't know whether there's agreement on that, and I think there is. Generally, both sides have understood the importance of protecting proprietary information. And indeed, when we had an amendment offered, I think, in the conference about, I think it came from the Senate on an Office of Financial Information, there was some concern on both sides that it was being too intrusive in getting private company data. So that's one of the things we have to look at. And so we can obviously take a look at that. I do think it's going to be very important here, and I know you and I have discussed this, and I appreciate that we hear particularly from the enforcement people. And I think if the enforcement people could give us their very specific needs on this, that would be very helpful to us. Let me also say, we have a couple more weeks. I am going to be, we'll be talking together across the aisle. I'm hoping we can come together on something. I think some legislative action would definitely happen. The Senate has already talked about this. So it would be my hope that by the end of next week, we could get some agreement on where we are on all this, so that we could probably do something on suspension that would be necessary in the final week before we get out in the Senate would, so that this would be taken care of. But that, as I said, was the question about statutizing. But let me just say one other question that has to be asked. The concern is that because things are subject, well, you did say, if I heard you correctly, because I was in and out, that you would not be invoking this with regard to the litigation that Fox has brought. Is that correct?
That's correct.
So this will not affect their lawsuit?
No, it will not. We've made it quite clear in the guidance that where the United States is a party, either prosecuting or being sued.
And have you made that, so does that
it's clear in our guidance. The guidance was unanimously.
Has that been clear in whatever court processes are going on with regard to the Fox lawsuit?
Yes, that's exactly right. About a month ago, I asked the staff, I directed the staff not to use 929I under any circumstances until the commission could.
So this is irrelevant to the Fox litigation?
Yes.
Appreciate that. Let me ask one last thing, and it might be helpful to the argument that you and your predecessors and others have been making. Are there examples of resistance that came from the subjects of investigation because of the concern that through FOIA proprietary information would be made public? That would be very helpful for us to know. Is this a theoretical fear, or have you in fact encountered this? I see Mr. Pitt is here, and I'll put him on notice. I'll be asking him if he can think of any examples of that as well, because I think that would be very relevant for us.
Mr. Chairman, we have, I believe you'd stepped out of the room, but we have many examples with respect to proprietary trading algorithms, with respect to investment advisors and fund managers' personal trading records, with respect to internal audit reports, and I'd be happy to supplement.
Where people have resisted giving them to you on the grounds that they would be,
Yes.
Well, I apologize, and I should have asked before I duplicated. Gentleman from California.
Thank you, Mr. Chairman, and thank you, Chairman Schapiro. Let me just, from the prior question, so I appreciate, as I understand it, your agreement that 929I is overly broad and would accept some codification of some restrictions in that regard, correct?
Yes.
Until that occurs, this guidance that you've given, can be changed, can be modified, whatever. Would you agree that any changes or modifications to this guidance you would inform this committee immediately prior to, in case, as the chairman suggested, we're running out of time on the legislative clock this year?
I would be happy to do that, and you should know this is commission guidance. The commission voted to issue it, so it is not just my decree as chairman, but I would be happy to notify the committee if there were to be any change.
Okay,
Which would,
thank
of course,
you.
have to be
Or
voted
enforcement
on.
of it or whatever within the commission. Thank you. One question. Now, this would be out of the purvey of this committee. This would be in government oversight because of FOIA. One of the things you mentioned is the lack of in your guidance that you issued yesterday, is the lack of a definition of financial institutions. Is that something that government oversight should be looking at? Is a better or a complete definition of financial institutions for FOIA?
I believe that it is it is undefined. It's generally been defined by reference to the Government in the Sunshine Act, I believe, but it doesn't include in that list all of the, for example, new entities the SEC will have responsibility for regulating, such as municipal advisors or some like credit rating agencies, which have never been found by a court to be a financial institution. It could be defined, I suppose, with a longer list, or it could be defined to say that regulated entities
Perhaps.
which are examined by the Securities and Exchange Commission are financial institutions.
Right, because there could be new regulated entities 2 years
Exactly.
from now that don't exist today, that, entities that we don't even
Exactly.
know about at the moment. As has been discussed, we're here because of the Fox Business Network thing and so forth. Can you, and to what extent I don't know because of a lawsuit, but it does appear to, certainly to this member and I think to other members, that withholding information on entities that on the Stanford and Madoff entities is hard for us to understand why that's a proprietary or confidential issue.
Congressman, I understand that concern, and I will say that while we could have withheld many documents, we've turned over tens of thousands, and a judge will obviously make the ultimate decision about whether additional documents should be turned over. But there is ongoing litigation with respect to Madoff and Stanford, and we are only relying, I should be very clear, on existing FOIA exemptions to withhold any information in the Fox litigation. But there is information that has the potential to impact the ongoing investigation of parties related to Madoff that we think is important for us to protect until such time as that litigation is concluded. And then I would imagine many more documents will be released.
Okay. I guess I'm still trying to understand. So initially, was 929I used to deny release of documents, and then now you've released more by using the previous or existing FOIA? I'm just trying to understand how this works.
My understanding is that we originally relied upon existing FOIA exemptions and only existing FOIA exemptions. My understanding is also that we've never filed anything with the court or officially presented to the court 929 as an additional basis for withholding documents, but it was, I understand, and again, I wasn't there, discussed in a conversation between Fox and SEC lawyers and potentially a clerk of the judge, that 929 could conceivably be an additional basis for withholding of documents. That was before I directed the staff not to invoke 929I. In fact, that's what brought it to all of our attention, as the chairman suggested. But it has never been put into a pleading or officially put before the court. We are not relying on 929I now as this litigation continues. We are relying only on existing FOIA exemptions as we have all through this litigation.
Okay, final question in my last seconds here, related to something that Ranking Member Issa mentioned, that 87% of FOIA requests have been denied by the SEC. I presume that is your chairmanship, the prior chairman, a number of chairmen, I presume. That does seem like a very high number. Is that because of a lot of, would you like to explain?
Sure. We're a bit unusual with respect to FOIA. For example, we have had over 10,000 FOIA requests this year at the SEC. I will tell you that the FDIC, the Federal Reserve Board, and the CFTC combined had about a third of that, 3,500. So we
Had a third of those requests?
have a third as many requests.
third as many
so those
requests.
three agencies have about 3,500. We have over 10,000. 70% of our requests come from commercial vendors of information who are seeking information for due diligence purposes or to repackage and sell in other contexts, which I think is very interesting. And 75% of those requests find no information. So that's by far the largest percentage of our FOIA requests. There's just simply no information found because of the request.
Saying you're actually not denying anything.
Not,
you're saying that
that's right.
You are complying with the
Right.
request. There's just nothing there.
Right. So to perhaps put the statistics in the best light for the Securities and Exchange Commission, 79% in fiscal year '09 were either granted in full or no information was found. But 64% of that was no information found. 12% of requests were denied in full or in part. The other reason I think we have a higher denial rate, quite honestly, than other agencies is our law enforcement function. And we, by far, the most used exemption by the SEC is Exemption 7, which goes to law enforcement activities.
Thank you.
Gentleman of North Carolina.
Thank you, Mr. Chairman and Madam Chairman. I'm sorry I've had to miss your testimony. I've got two really wonderful hearings going on in my two committees at the same time. Judiciary is hearing something on digital competition in the digital world, and it's extremely exciting, and I thought I wanted to go over there and hear that testimony. I just have one question. I, for the first time, have seen this May 18, 2010 report of the Committee on Oversight and Government Reform, since I don't sit on that committee. And it seems to be a rather scathing indictment of the SEC in a number of respects. And I was wondering whether there are any specific parts of the findings of that that you would dispute vigorously, or you think overstated, or is it generally true when you came in, and are these issues being addressed?
Congressman, that's a minority staff report, which I have to say I read when it was released, but it's been several months, so I would be hard-pressed, I think, to give you specifics, although I'd be happy to do that for the record. I will say that I think it doesn't recognize extraordinary changes at the SEC over the last 18 months. And while we have a long way to go in terms of rebuilding our culture, ensuring that our focus is always on market integrity and investor protection, we've made a lot of changes that respond to the specifics that are raised in that report. And you've heard me testify many times about the post-Madoff reforms, the post-Stanford reforms, the failure of the Consolidated Supervised Entity Program, the bankruptcy of Lehman Brothers and others, the lessons the SEC learned from those, and the actions that we have taken with respect to new leadership throughout the agency, new training, new skill sets, new regulatory programs where appropriate to deal with these kinds of issues and problems. We have really left no rock unturned to try to make sure that this agency is one that the American public can rely upon. But with respect to the specifics in that report, I would be more than happy to provide something for the record. As you can imagine, I don't agree with some of the characterizations.
Thank you for doing that, and I would ask you to do that. I'm happy I asked the question because you called to my attention that it is the ranking member's report, the minority part of the committee's report, rather than the Committee on Oversight and Government Reform. It's probably not even advertised well, because it says right at the top, U.S. House of Representatives Committee on Oversight and Government Reform, in great big letters. And then it says right under that, Darrell Issa, California 49, ranking member. It seems to me if Mr. Issa were going to do a report, he could at least caption it appropriately. So I'd welcome your responses so that we can get a clearer picture of not so much what the history of the SEC has been, but what changes are being made to make it a more effective advocate for consumers and protector of the public. So with that, Mr. Chairman, I didn't hear the testimony, so I'll yield back the balance of my time.
Gentleman from Florida.
Madam Secretary, I wonder if you could share with us, we've talked about the denials of the Fox request. Share with us exactly what was requested and exactly why it was denied.
I would be happy to do that. I would like to not be incomplete, though, in my response, so I would prefer to do that for the record. I can tell you generally, at the risk of leaving something out, that they sought tips and complaints and what we call TCRs, tips and complaints and referrals with respect to Madoff conduct prior to his, I believe all of them, not just prior to his arrest, 2004 and 2005 examination reports, information with respect to the 2006 and present enforcement investigation, and then materials surrounding the Office of the Inspector General's investigation. But I don't want to represent to you that that is everything. I would need to do that for the record.
Well, could you give me an example how that might interfere with any current proceedings now, even hypothetical if you want to? That sounds like a very reasonable request to me. The case is closed. The SEC did nothing. Nobody was punished. We don't even know where all the people were that screwed up now. I asked you that last time and you couldn't tell me. Give me an example of why we need to protect this as proprietary information.
Congressman, first of all, you should know we have turned over tens of thousands of pages in response to this request, and a federal judge will make the decision whether, under existing FOIA exemptions, the SEC has appropriately withheld additional information. I can imagine that there could be information with respect to related parties to Bernard Madoff Investment Securities that may well be subject to investigation and ongoing enforcement by the Securities and Exchange Commission or the United States Attorney's Office that would not be in the interests of those investigations and actions to be disclosed. But that's a hypothetical because I don't know the specific answer to that. Be happy to try to provide that to you.
Yeah, it just seems like they're asking for records that are over 4 years old, and as old as how old are some of the records they're asking for?
Again, I don't know the very detailed specifics of their requests, but there's no question that these date back a number of years. But again, many tens of thousands of documents and pages have...
Will the gentleman yield?
Yes, sir.
Chairman, piece of advice. When someone asks you why you haven't turned over anything, the fact that you turned over 10,000 is not a good answer. Frankly, it sounds to me like the lawyers kind of cooked up an answer for you. And I'm going to just give my advice. It's like all the days you didn't rob anybody, not that you robbed anybody. I mean, the fact that you turned over pages is no answer to the question. The other thing I would say is this. The fact that a judge will ultimately decide it doesn't answer the question because the judge isn't preventing you from doing it. So, again, you may have other reasons, but I would just recommend the question was why not turn these over? The fact that you have turned over other things, not an issue, or that a judge may make you turn them over, doesn't go to your rationale for not turning them over.
Well, I should say, Mr. Chairman, I have a bias. We have a bias towards turning over anything that we can. There are ongoing law enforcement investigations by the Securities and Exchange Commission and the United States Attorney's Office with respect to individuals and entities associated with Madoff. And I believe that is the basis.
The gentleman would yield again. That gets right to the point that I think the gentleman did. Let me make this proposal to my colleagues. That is, next week, would you be willing to conduct a confidential briefing, a members-only briefing, that might give some more specifics about some of this? I think that would be very helpful, and that members who wanted to go could go. If you could agree to do that, get back to us, I think that would be very helpful where you could discuss some of this information. Because I realize there might be some constraints. I mean, if it's legitimate not to FOIA it, then that would be undercut by talking about it here. But I think if you were able to do your enforcement people could do a members-only briefing next week, that might be helpful. An additional 2 minutes.
Well, thank you very much, Mr. Chairman. That would be very helpful. My experience, and I've had a little bit of experience with some of the government agencies over the years, usually they want to avoid any sunshine to protect incompetency, not to really do the more upscale performance that you have suggested. And I'm not suggesting that yours is going to protect any unknown incompetency any further, but that's just been historically why I have seen agencies stonewall letting documents open to the press. And I guess every member of this committee has made it very clear and have been fairly passionate about the need to have transparency in government. And so I'd be interested in having the questions answered in private, as the chairman suggested, if necessary. And I'd also just be curious to know if the agency's call was wrong in withholding information that should be public, what are the consequences? What are the penalties for the employers that made that bad call?
Well, the staff makes the decision based on expertise and guidance and counsel from the General Counsel's office about whether or not information needs to be disclosed. We don't punish people if they made a wrong call about whether a document could legitimately be held under a Freedom of Information Act exemption. If somebody had a pattern of making bad calls or judgments, we would have to take that into consideration in a performance evaluation.
I think I got my answer. Just like the Madoff scandal, nobody's even had their wrist slapped. And I think maybe when we look at reforming the agency, we might want to put a little bit of personal responsibility and accountability there for that. I mean, right now, if there's no penalty whatsoever for making bad calls, and if anyone's ever been disciplined by the SEC, I'd like to know about it because I haven't yet. I've read some books. I've read all I could on the issue. I've heard the supervisors testify. I've heard the secretary testify. We know nobody has been punished yet about the Madoff mishandling. We don't even know where those people are now, the 2 to 3 dozen examiners and investigators who blew the whole thing. I was under the impression you were going to find out for me and let me have that information, but I haven't received it yet. But I think what everybody's alluding to is we just want to see some accountability. I mean, that's what this whole thing is about. And as the chairman said, we ask an agency head what time it is, and they start describing the clock till our time runs out. And I just wish we'd stop some of the game playing and just be kind of frank and forthright with this stuff. Thank you, Mr. Chairman, for the extra time.
Gentleman from Kansas.
Thank you, Mr. Chairman. Chairman Schapiro, you mentioned in your testimony that on September 25, 2009, the SEC's Inspector General issued a report entitled Review of the SEC's Compliance with the Freedom of Information Act. That report contained 10 recommendations with respect to strengthening FOIA, most of which the SEC concurred with. 2 questions. When you became the chair of the SEC, were you aware of these problems with respect to FOIA compliance, or was the IG report the first time you were made aware of these problems? And the second question, you also mentioned one remaining item from that report that has yet to be resolved. What is the issue, and why has that not been resolved yet?
Congressman, the Inspector General report, as you point out, was issued in September of 2009, and within a few weeks after its issuance, I hired a new Chief Freedom of Information Act officer with deep experience in this area. As you say, the IG made 10 recommendations. All 9 have been closed out to the satisfaction of the Inspector General. The one that remains open relates to developing new performance standards for employees in the Freedom of Information Act office, and we are working on that. It is only not resolved because it actually will require negotiation with the SEC's union in order to do that.
Okay. And, okay, very good. Thank you. You're back.
Texas, Mr. Hensley.
Thank you, Mr. Chairman, and forgive me, Madam Chair, I missed your testimony, so we may cover some old ground here. I understand that you have previously stated, and perhaps you stated in your testimony, that 929I is necessary or helpful because it eliminates uncertainty. Is that correct? As I understand it, the Commission's guidance says that, quote, the Commission should make disclosures where permitted by law when the need for confidentiality is outweighed by the public's interest in accountability and transparency. So I guess my first question is, if the Commission still reserves the right to disclose information whenever it decides that the public has this interest in accountability and transparency, how is it that regulated entities achieve a greater level of certainty than with 929I?
Because I think regulated entities with whom we work on a daily basis understand that the Commission appreciates the competitive harm that can come from something like disclosure of a high-frequency trader's algorithms. And so they have a higher level of comfort that the agency, as an expert in these kinds of matters, will in fact understand the potential damage from certain kinds of disclosures.
I'm not sure I still understand.
No, it's not.
I'm still
right.
confused by the nexus to 929I.
It's not ironclad in the sense that, yes, just like under FOIA, FOIA doesn't prohibit you from disclosing anything. It gives you the ability to not disclose certain kinds of information. So, yes, you're right in the sense that the agency has discretion in many areas to continue to disclose even where there might be an applicable FOIA exemption. Nonetheless, as I said, regulated entities trust that the agency understands that to produce a list of holdings by a hedge fund or a mutual fund, or to produce a trading algorithm that would allow someone to trade against that firm's interests would be potentially devastating to those entities and wouldn't do it.
This is a fairly basic question. As the years have gone by, Congress has increased the authority of the SEC in a number of areas, including the authority to compel registered entities to provide information in records. So number one, clearly under the 34 Securities and Exchange Act, I'm under the impression you already have the power to subpoena witnesses that require the production of records from registered entities. I understand if they fail to comply, you have the authority to suspend these entities. You can impose monetary penalties. You can refer the cases to DOJ. And I'm just trying to figure out, why is it that 929I is needed, or is it needed to somehow convince registered entities to cooperate? Well, what does it add to the mix?
Congressman, I can tell you that we have examples where registered entities have refused or held up dramatically our examinations by not giving us information. We could use a subpoena. There's no question about it. I don't actually think they'd prefer to get a subpoena. I actually think they'd prefer to voluntarily produce information or produce information pursuant to our examination authority and understand that it can be protected, rather than actually require us to go and sue them, leading to all kinds of additional issues for that entity. I also don't think it's the best use, honestly, of the SEC's enforcement resources to spend a lot of time having to pursue regulated entities to give us documents that they frankly should be giving us under our examination authority. I think you all and we would rather have them out there looking for fraud and prosecuting violations of the securities laws. I know, and I think you'll hear on a later panel, that lawyers counsel their regulated entity clients to try to always cooperate and provide information to the SEC, and that will be easier to do if there's a higher level of comfort that we can protect that information from disclosure to competitors.
My time's about to run out, and perhaps prior to my arrival here, some of the legislation that deals with this has been discussed. Can I assume that you're familiar with H.R. 6086, Chairman Towns' legislation, which appears not to be a straight repeal? Are you familiar with his legislation?
Yes, Congressman, and he was here, actually.
Well, I'm sorry I missed
That's
that
okay.
portion, but could you comment briefly on your opinion of his legislation?
Sure. It would repeal 929I, but it would add a provision which we think is quite important, making it clear that under FOIA Exemption 8, any entity that is regulated and examined by the SEC is considered a financial institution. I think where it's not as helpful is in the context of third-party litigation, where two parties, private parties, are suing each other, serve the Securities and Exchange Commission with a subpoena to get information about each other that's potentially competitively damaging. And we don't have the capability without 929I to have a relatively high level of assurance that we would not have to disclose that information. I do believe that that's an issue that we can resolve.
Yeah, and I'm told, by the way, that the Senate Judiciary Committee has voted out by voice vote a bill that's very close to the Towns bill. So we'll be, and I have previously said I I'm asking everybody now, let's think about this, and by the end of next week, I'm hoping we might be able to come to a consensus here, so that'll give us enough last week to act on something. The gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman.
You say, Madam Chair, we're going to have some votes, but it now looks to me we only have 2 more members. After this, we'll be able to finish with you and then go to the votes and come back for our third panel. Mr. Green.
Thank you, Mr. Chairman, and thank you, Madam Chair, for appearing today. I am a person without a made-up mind as to what the remedy is, and I welcome your testimony because the intelligence that you are according us is going to be very helpful. I'd like to make a comment and receive your response, if I may. You have mentioned the ongoing investigation exception, but what we haven't said, and perhaps it's assumed but hasn't been said, is simply this, that that exception exists because persons who are being investigated have a way of allowing their factual circumstances to metamorphose. They don't remain static. They're somewhat dynamic. And as they receive information about what you may have, they can sometimes conform their defense, if you will, around what they know your offense can produce. Is that a fair statement that the ongoing investigation exemption is to allow you to effectively prosecute if you have to?
That's absolutely right. There's one part of Exemption 7 that is geared towards protecting law enforcement techniques. Might, in our case, be how we look at certain kinds of trading information and sift through it to find particular patterns of trading or practices. But there is an exemption that specifically contemplates that law enforcement needs to be able to protect some of its techniques from disclosure.
And with reference to proprietary information, this is a highly competitive industry that you regulate. And every edge that you have as a business person, you want to protect to the extent that you can. And competitors will sometimes want to acquire the information that they can about your edge so as to negate your edge. And proprietary information, simply put, as I'm understanding it today, is to protect the edge that you have as you try to compete in a highly competitive market. And if there's a way to acquire information about that thing that helps you to succeed, others will co-opt it and use it perhaps, and it won't hurt you, but it could also work to your detriment for this to be utilized by your competitors. Is that a fair statement?
That is fair.
So you're trying to protect proprietary information, you're trying to protect ongoing investigations so that they can be effectively prosecuted, and in so doing, you're trying to balance this need of the public to know about these things. And there is something called judicial determination. When you reject a request, there is an opportunity to have a disinterested third party known as a judge to look at it and say either you made the right call or you made a bad call. Is that a fair statement? Is that process lengthy? Is it, and I want you to be as candid as you can be. I know that we all have our biases, but is that a lengthy process to the extent that it is seen as a means by which persons simply go into some never land and they never get the results that they want?
I don't know the specific answer to that. I have no doubt that it is a process for sure, and that there are costs associated with having to appeal a FOIA denial to a federal judge. And so as a result, I think our bias should be that wherever we can, we should release information unless it is going to clearly fall within one of the existing FOIA exemptions or cause real commercial harm to an entity.
With my final seconds, 10,000 requests so far this year. How many people do you have working on just managing these requests? It seems to me that that takes an inordinate amount of personnel and you have to have support systems. Talk about that, if you would, briefly.
We have 30 people in the Freedom of Information Act office, but they also call upon people throughout the agency to actually do the searches for documents within each division or department to make sure that we've covered everything. We have some technology. One of the recommendations of the Inspector General was to improve our technological capacity to handle FOIA requests, and we've taken a number of steps in that regard to the satisfaction of the Inspector General. We've stepped up dramatically in the last year our training of employees so that they have the latest techniques in order to handle this just extraordinary, really, I think, by comparison to other agencies.
Thank you. My time has expired. Thank you.
Gentleman from Missouri.
Thank you, Mr. Chairman. I have just one question. I'm concerned about repealing a law that's only been on the books for a minute or two. Do you believe that we have had enough time to evaluate it, or do you think we need more time for evaluation?
Well, Congressman, I think, it is a fair argument that 929I as drafted is broader than it needs to be to protect the information we believe needs to be protected, which is why we did guidance that we think really hits the right spot. It relies on existing FOIA exemptions, except with respect to whether something has been determined to be a financial institution. It gives us a little coverage there, and it helps us in the third-party litigation context. I think that's the right place for us to be, and whether Congress is satisfied that we have binding guidance as we do on our staff or feels the need to amend the law to achieve the same result, that's, I think, a judgment call for all of you. We really stand ready to help get that done.
So you said no comment. Thank you.
The timing is good. Chairman Schapiro, thank you. You have been very helpful. I hope everyone understands that. The guidance is helpful. Your responses were. I would urge you to think about a confidential briefing. I think that would be very much in your interest, because I think members are not closed-minded on this, but they get asked questions, and I would say, in my experience, the discretion of members of this committee can be trusted. We have not had confidential information inappropriately shared. We're going to recess now and then come back for our third panel. There are 3 votes. The first one will take about 20 minutes, the second to 5 each. I would say about a half hour we should be able to be back, so witnesses can take, if they want to get a bite or something. But we will be back here in about a half hour, and we will begin immediately with our next panel. We're in recess.
Thank you, Mr. Chairman.
And, I've known this. I said to people, you can't sit in a quiet room and then you look ridiculous. They say, whatever they ask you, say this. You look stupid.